Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. Today's episode will be another double feature episode, so be sure to stick around and watch our coverage of both interactions. The first interaction covers graffiti, criminal mischief, and arguable probable cause, and is brought to us by Lakey the Poets channel. Be sure to check out the description below and give them the credit that they deserve. Just before an impending rainfall on May 15th, 2023, chalk artist Joshua Lakey Hinson was drawing with chalk on a public sidewalk in Leon Valley, Texas, when field training officer Jorge Breton of the Leon Valley Police Department and his trainee, Officer Alan Gonzalez, responded to an anonymous call alleging that Mr. Hinson was defacing public property. The interaction that followed was captured on Officer Gonzalez's body camera.
What's up, Papa? How's it going? Good.
Sit down, man.
Okay.
What's all this that we're doing here?
Somebody called us because you do graffiti. So you don't have a permit. Unfortunately,
it's freedom of expression to create on public property.
It's public, yes.
Yeah, I've been arrested and won in court 3 times now. So I mean, if y'all need to arrest me for it, we can arrest me and then we can go to court after that.
Man. You just have an ID on you?
What am I doing wrong, man?
Well,
I'm creating and it's about to rain and wash it all away.
Yeah, that's my concern. That is not. Could you stop it, please? Could you stop it? Just stop. Okay?
This is impermanent, man.
Come right here, please. Sit on this way.
You have your ID on you, man?
Hey,
the police are out here messing with me. I'm just trying to do my sidewalk shot.
Hold on. It's okay. We try to talk to you. You don't listen. We try to be civilized. We want to give you a break. Now you're pushing us to do this. Yes, no, you are.
Because you're bullying.
Oh, we're bullying. So, breaking the law.
Sidewalk.
My car. It's also simple, man. All you have to do is just give me your name and that's it. I told you I wasn't trying to go this far, alright?
Well, you're going this far and you chose to.
Yeah.
I need my stuff.
Go ahead and get it.
Huh?
We'll go ahead and get it right now for you. What's your name, man? You don't have an ID on you?
You know what's in my pocket?
Can I go ahead and grab it?
I mean, I don't have any other choice, do I? Y'all have already pumped me for a sidewalk.
Is it in this wallet right here? So you're just trying to get some tip money off of that or what?
Yeah.
Gotcha.
Trying to create beauty in a public place.
As long as you don't have a permit for that.
You don't need a permit.
No? Okay. You can explain that to the judge, okay?
You have any weapons on you, man?
No.
Any knives? Anything's gonna poke or shake me?
My backpack, my artwork over there.
Alright, man. Just do me a favor. Just go ahead and I'm gonna go ahead and sit you in the back of my patrol car, alright? And then we're gonna figure out what we're gonna go ahead and do, alright? This time you're just detained. You're not free to leave.
Take his phone. These are the elements of the crime. These two. This one, I don't know. It's not mine. So evidence, let's take that.
Okay.
Graffiti.
Okay, we're gonna book them?
Yeah.
For graffiti? Alright.
Yeah. Definitely. Okay.
Officer Breton tells Officer Gonzalez that they will book Mr. Hinson for graffiti. Section 28.08 of the Texas Penal Code, the state graffiti statute, prohibits the intentional or knowing making of so-called markings, including inscriptions, slogans, drawings, or paintings on tangible property with paint, an etching or engraving device, or a quote-unquote indelible, meaning permanent, marker. Accordingly, because Section 28.08 does not prohibit making markings with chalk, as Mr. Hinson was doing here, it is was highly likely that a court would conclude that his actions did not violate the state graffiti statute. Additionally, Section 8.03.033 of the Leon Valley Code of Ordinances prohibits an individual from having a quote-unquote graffiti implement in their possession on public premises that are closed to the public or on private property for the purpose of defacement. Well, not only was Mr. Hinson on public property while it was open to the public, but Section 8.03.031 of the Leon Valley Code of Ordinances defines a so-called graffiti implement as, quote, any aerosol paint container, any type of felt tip marker or paint stick or etching tool capable for scarring or otherwise defacing glass, metal, concrete, or wood, or any petrochemical or other synthetic material used in construction. As this definition does not include chalk, it is almost certain that a court would find that Mr. Hinson did not violate the Leon Valley Graffiti Ordinance. However, Section 28.03 of the Texas Penal Code, which codifies the offense of criminal mischief, states that, quote, a person commits an offense if, without the effective consent of the owner, he intentionally or knowingly makes markings, including inscriptions, slogans, drawings, or paintings on the tangible property of the owner. Now, unlike the graffiti statute, the criminal mischief statute does not specify the type of implement that must be used for the statute to be violated. Instead, the statute simply prohibits the making of markings, without any apparent limitation on the type of tool that must be used. Now, I could not find any case law discussing whether the Texas criminal mischief statute applies to chalk drawings, but other courts have construed similar statutes to prohibit temporary chalking. For instance, in the 2011 case of Mahoney versus Doe, the U.S. Court of Appeals for the District of Columbia Circuit determined that a Washington, D.C. defacement statute that forbid writing, marking, drawing, or painting on any property without consent applied to chalking on the sidewalk in front of the White House. The court also held that the application of the defacement statute to chalking a sidewalk did not violate the First Amendment, despite recognizing that such chalking is protected speech, because the prohibition was content neutral, narrowly tailored to serve a significant government interest, and left open ample alternative channels of communication. In reaching this conclusion, the court noted that, quote, it is true the defacement at issue is temporary and can be cured, but the government can prescribe even temporary blight. As such, it is certainly possible that a court could decide that the Texas criminal mischief statute applied to Mr. Hinson's chalk art.
Do you check in? Do you frisk him?
Yeah, it's just paper. I haven't taken everything out.
Okay.
The officers place Mr. Hinson under arrest and take him to the police station for booking. Mr. Hinson's arrest was also recorded on Officer Breton's body camera, which captured a conversation between Officer Breton and his supervisor, Sergeant Chad Mandry, once they arrived at the station.
Graffiti.
How much?
The whole crossing in the corner, by the bus stop on the how do you call it?
Marker or what?
No, it's chalk.
Okay, is that arrestable offense?
But yes, because he's chalk, marker, permanent marker, all that stuff. I'm gonna read the statute again. I want to give him a break.
In order for Class B, it has to be indelible, meaning non-erasable. So chalk is
I
washable.
don't know, with the water it's not washing off, so it's gonna take a little time.
But chalk, just be careful, because chalk is not considered a permanent marking.
Okay.
So
I told him, hey, what is this doing? I'm gonna give him a break. Hey, just stop. No, I'm doing art. This is my right. I can do this
you
in
did it on
public.
the sidewalk?
On the sidewalk.
Okay. That's probably not going to be an arrestable offense.
Yeah, we're gonna check it right now. If that is the case, just let him go.
Yeah, double check, but tell him to be careful, because if we bring something back here like that, then if we unlawfully detain them, then that opens up for lawsuit.
Okay.
Sergeant Mandry warns Officer Breton that because chalk is not considered a permanent marking, Mr. Hinson's arrest could open the door for a lawsuit for unlawful arrest. Now, as we've discussed before on ATA, Section 1983 of Title 42 of the U.S. Code allows individuals to file lawsuits against officers who violate their civil rights, such as when they arrest them unlawfully in violation of the Fourth Amendment. However, as the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, explained in the 1994 case of Babb v. versus Dorman, officers are granted so-called qualified immunity from having to participate in such lawsuits, now quoting, unless their conduct violates clearly established statutory or constitutional rights of which a reasonable person would have known. The court also stated that when deciding if an officer should be granted qualified immunity in an unlawful arrest lawsuit, courts must determine whether, now quoting again, a reasonable officer could have believed the arrest to be lawful in light of clearly established law and the information the officer possessed. Even law enforcement officials who reasonably but mistakenly conclude that probable cause is present are entitled to immunity. This concept is known as arguable probable cause, meaning that even if a court determines that an officer did not actually have probable cause to make an arrest, if a reasonable officer could have determined that probable cause existed, well then qualified immunity still applies. Accordingly, even if a court concluded that the Texas criminal mischief statute did not apply to Mr. Hinson's chalking, well, it seems likely that a court would conclude that the officers had arguable probable cause to arrest Mr. Hinson for criminal mischief, given the plain language of the statute that simply prohibits the making of markings on property without consent, and the lack of case law establishing that the statute did not apply to chalking. Additionally, the fact that the officers arrested Mr. Hinson for an alleged violation of the graffiti statute rather than the criminal mischief statute is irrelevant to the analysis of whether the arrest was lawful. Instead of looking at the officer's subjective reasons for making an arrest, courts considering qualified immunity determine whether probable cause to arrest for any offense objectively existed. As the Fifth Circuit Court of Appeals noted in the 1973 case of United States v. Saunders, quote, when an officer makes an arrest, which is properly supported by probable cause to arrest for a certain offense, neither his subjective reliance on an offense for which no probable cause exists, nor his verbal announcement of the wrong offense vitiates the arrest. As such, there is a decent chance that a court would grant Officer Breton and Officer Gonzalez qualified immunity if Mr. Hinson were to file an unlawful arrest lawsuit against them. Now, while Officer Breton spoke with Sergeant Mandry, Officer Gonzalez transported Mr. Hinson inside the police station.
All right, man. So this is our police department. We're just going to hold you and process all your stuff. Just going to go ahead and get everything you got on your pocket top. Going to take a seat, all right?
Mr. Hinson was held at the police station for approximately 30 minutes before he was released without being processed or booked. No criminal charges were ever filed. After his arrest, Mr. Hinson filed a formal complaint against Officer Breton and Officer Gonzalez. He also spoke at a city council meeting and called for Officer Breton to be fired. Officer Breton was not terminated from his position, but he was removed from his training duties and given a written reprimand. The department did not discipline Officer Gonzalez due to the fact that he was still in training during the incident. The city of Leon Valley issued an official apology to Mr. Hinson and held a Chalk the Walk event at the Leon Valley Public Library in an effort to show that the city welcomes public chalk art. Mr. Hinson retained a civil rights attorney who threatened litigation. As a result, the dispute was resolved before a lawsuit was even filed, with the city of Leon Valley agreeing to pay Mr. Hinson $16,500 on July 19, 2023, approximately 2 months after he was arrested. Overall, Officer Breton and Officer Gonzalez get a C-, because although it seems likely that they would be granted qualified immunity for their arrest of Mr. Hinson, they maintained unnecessarily aggressive demeanors throughout the encounter, demonstrated a substantial lack of knowledge regarding the Texas graffiti statute, and failed to reasonably exercise officer discretion. While it is possible that a court would find that Mr. Hinson's conduct violated the state criminal mischief statute, the officers arrested him for graffiti, an offense that Mr. Hinson inarguably did not commit. And despite the fact that chalking a public sidewalk could potentially be considered criminal mischief, I believe that a reasonable officer would have exercised their discretion and chosen not to arrest Mr. Hinson for peacefully creating non-permanent and aesthetically pleasing chalk art on a public sidewalk, particularly given the fact that the coming rain was about to wash all the chalk away. This encounter demonstrates what can happen when officers make unnecessary unnecessary arrests of individuals who are not causing any harm to the community. Mr. Hinson gets an A- for maintaining a calm demeanor throughout the encounter, complying with his arrest and challenging its validity afterwards, and taking proper action after the encounter by filing a complaint, speaking to the city council, and hiring a lawyer. Although a court could potentially determine that his harmless chalking constituted criminal mischief, I personally believe that this interpretation of the statute would be unreasonably restrictive, particularly given the non-permanent nature of chalk, the complete lack of damage caused by chalking, and the unique opportunity that public sidewalks give chalk artists to share their creative expression with the community. That being said, I would caution Mr. Hinson to remember that it is possible that a court could find his chalk art to be illegal, so he may want to obtain consent from public authorities before chalking on public sidewalks in the future, at least in Texas or any other state with broad prescriptions against making quote-unquote markings. The next interaction covers jaywalking, identifications, and pretextual stops, and is brought to us by James Madison Audits' channel. Be sure to check out the description below and give them the credit that they deserve. On October 23, 2020, Sergeant Jeremy Bird of the Port Orange Police Department in Florida received a text message from Officer Andre Fleming informing him that City Councilman Drew Bastian had called him to report seeing an individual dressed in quote-unquote all black trying to film over a wall located on the perimeter of the Port Orange Police Department. According to his police report, Sergeant Bird sent Officer Preston, Officer Yovanovich, and Acting Sergeant Kurtz to attempt to locate the quote-unquote subject, who was later identified as James Newmeyer, a local citizen who had visited the police department to attempt to file an officer complaint. Somehow, the responding officers came to believe that Mr. Newmeyer was reported as trying to climb over the wall, and the interaction that followed was captured on body camera.
Somebody's supposedly climbing our wall with a mask on over here. Andre called it in. Yeah, over here. Somewhere on this wall on Clyde, he said. Andre called it in. See anything?
The guy walking on the sidewalk, he had a mask on, he's just texting.
In black?
Black pants, black shirt, Caucasian.
Okay. I think that's the guy he was saying was trying to climb our wall there. Because Andre saw it, so 12 to 15.
Go ahead.
Hey, I guess he's walking southbound on Clyde. Next to the PD now. Dressed all in black. Supposedly he's walking down this way.
He's walking north.
So.
Charlie 90 Patrol, take the McDonald's call.
Hello. Hey, were you trying to come over our wall here?
Hell no. Do I look stupid?
No? We'll get you for 1 second because we had a call of a guy dressed in black that was climbing up on one of our walls there.
Hell no. Ain't you guys got cameras?
Uh-huh. Do you have an ID card with you? I'll call Fleming. Hey, Sarge. Can you call Fleming? Who messaged? Where did Fleming mess? Who did he message? What's that? Was that you?
Yeah.
Well, we're out with the guy dressed in black that's running right along here, so.
He said he had a citizen call.
Oh, so he didn't see it?
No, he didn't.
Jesus Christ.
All right, yeah, I think I'm going to have to go to court. Let's see.
All right. Well, great. I thought he saw.
Oh, he's doing it like that.
Yeah. All right.
He's refusing to give his name or any information.
Hey, I don't like cops. I don't talk to cops. I don't deal with
Okay.
cops. I was minding my business, looking at my phone, walking down
He
the
stated to
sidewalk,
me-
and I was stopped.
Freely, he stated to me that he was inside the lobby trying to make an officer complaint.
Okay.
Figured out it was closed, so he left the the lobby, and came onto the road. The sidewalk and came this way. So he was trying to make a complaint, but
Okay. Well,
so it's
I
closed.
can help you with that.
No, you can't.
Yeah, I can.
No, you can't. I'll be here Monday through Friday during business hours to talk to a supervisor.
I am the supervisor.
I don't care.
Well, that's. If you want to make an officer complaint, I'm the guy to
I'll
talk
put
to.
it in writing. You ain't gonna do nothing. You protect your
Sir,
blue
he's a
line
sergeant.
brothers. I don't care. You're the blue line brothers. He ain't gonna do.
Say what?
I said you protect your blue line brothers. You ain't gonna do.
Based on what?
Based on police. That's what's based on.
You don't know
Based
me.
on I don't need to know you. You're a blue line. That's all you are to me.
Okay.
You don't give a damn about nobody but your other blue line people.
So we're trying to.
All right.
You ain't trying to help me do. Right now you're harassing me on the side of the road. Am I being detained or am I free to leave?
You're free to go.
Thank you. Oh, y'all.
Keep an eye on him as he... Look up. He's wearing an auto shirt. See if anything happened.
Oh, we have. Oh, this guy?
Yeah, because we don't even have an ID. We don't have any.
He wouldn't give ID.
No. But he's wearing an shirt, so we can probably figure out who he is.
Do you know if he's parked in the front parking lot or anything like that?
I don't know. You want to go? Preston. Go to the. See if he's got a tag on the car in the parking lot. Now you're detained for jaywalking, running across Clyde Morris like that.
How else am I going to cross?
That's what crosswalks are for.
There isn't a crosswalk within 150 feet. I know you cross at a
Well, now you're
90-degree
detained.
angle when there's no crosswalks within 150 feet.
You're detained,
You're illegally detaining me.
and now you have to identify yourself.
No, I don't. I want a supervisor.
I am the
I
supervisor.
want your supervisor. I didn't do anything wrong. I committed no crimes. I am not giving you my ID.
Sergeant Byrd tells Mr. Newmeyer that he must give identification because he is being detained for jaywalking, and Mr. Newmeyer refuses. The term jaywalking is not used in the Florida statutes, and Section 316.130 of the Florida statutes, which outlines pedestrian traffic regulations, actually allows pedestrians to cross a roadway outside of a crosswalk as long as they use, now quoting, a route at right angles to the curb or by the shortest route to the opposite curb. There is an exception to this general rule, as the statute does prohibit pedestrians from crossing at any place except a marked crosswalk between adjacent intersections at which traffic signals are in operation. The statute also requires every pedestrian crossing a roadway at any point other than a crosswalk to yield the right-of-way to all vehicles upon the roadway. A review of the Google Maps Street View confirms that Mr. Newmeyer did not cross the street between adjacent intersections at which traffic lights were in operation. So, in order to lawfully detain Mr. Newmeyer on suspicion of jaywalking, Sergeant Byrd would need to have reason to believe that Mr. Newmeyer failed to yield the right-of-way to vehicles on the roadway. In his police report, Sergeant Byrd stated that he drove out of the police department and was traveling south when he saw Mr. Newmeyer crossing the street. Sergeant Byrd wrote, quote, "As I was approaching, I slowed my speed at an estimated distance of 30 to 40 yards as it was dusk and I could not see him well in an effort not to strike him. However, Sergeant Byrd's body camera footage does not capture Mr. Newmeyer crossing the road and shows that Sergeant Byrd made several U-turns before stopping Mr. Newmeyer. I cannot tell for certain from the footage whether Sergeant Byrd had to slow his vehicle to avoid hitting Mr. Newmeyer, but Sergeant Byrd's body camera did not capture any evidence that supports the theory that Mr. Newmeyer failed to yield the right-of-way to vehicles in the road. As to whether Mr. Newmeyer was required to identify himself, according to Section 901.151 of the Florida statutes, which codifies the so-called Florida Stop and Frisk Law, quote, "Whenever any law enforcement officer encounters any person under circumstances which reasonably indicate that such person has committed, is committing, or is about to commit a violation of the criminal laws of this state or the criminal ordinances of any municipality or county, the officer may temporarily detain such person for the purpose of ascertaining the identity of the person temporarily detained and the circumstances surrounding the person's presence abroad which led the officer to believe that the person had committed, was committing, or was about to commit a criminal offense." Now, although the statute states that officers must have reasonable suspicion that an individual violated a criminal law, and violations of Section 316.130 are considered non-criminal traffic infractions, the U.S. District Court for the Middle District of Florida held in the 2008 case of Copeland versus Bradenton Police Department that an officer was justified under the stop and frisk law in detaining an individual based on an observed violation of Section 316.130. As such, if a court determined that if reasonable suspicion existed for the officers to believe that Mr. Newmeyer failed to yield the right-of-way to passing vehicles, it is likely that it would also conclude that the officers could require him to identify himself.
Jaywalking is a traffic infraction. Jaywalking is a traffic infraction
I didn't jaywalk.
for which you are lawfully detained.
I didn't jaywalk.
Actually,
You're unlawfully detaining me. I did not jaywalk.
I actually saw you myself.
No,
so.
yes, I understand that.
I'll
You're
saw you
allo-
from- I'll saw you
you
from the
are
parking lot
allowed
over
to
here.
cross the street if there is not an intersection within 150 feet. You're allowed to
Not
cross
with
the
traffic
street
coming.
at a 90-degree angle. There was no traffic
There's a
coming.
lot of
You were the
traffic.
closest traffic, and you were far enough away from me to make it safely. You guys just want to ID me illegally. So go ahead, if that's really what you want to do, take my wallet, because Terry v. Ohio says you're not allowed to dig into my pockets without a reason. So if you really want to have a lawsuit filed against you, go ahead. I will sue you.
All right, so
I got him.
if you don't identify yourself,
Go ahead, take my wallet. It's right
You will
there.
be-
Take
you will
my
be
wallet
under
out of my
arrest.
pocket.
okay.
I'm telling you, go ahead, take
Take
my
his-
wallet out of
take
my
his wallet.
pocket. That's illegal. You're breaking my rights right now. You're violating my rights. That's a violation. You're not allowed to go in my pockets and take my wallet without reasonable
You
suspicion.
just told us to.
No, I
just said that.
You're threatening me with arrest. That's done under duress. You are threatening me with arrest.
That's correct, I am.
Sergeant Byrd claims that the officers took Mr. Neumeyer's identification with his consent, and Mr. Neumeyer argues that he only agreed under threat of arrest. As we have discussed before on ATA, the Supreme Court stated in the 1991 case of Florida versus Bostic that, quote, even when officers have no basis for suspecting a particular individual, they may generally ask to examine the individual's identification, as long as the police do not convey a message that compliance with their requests is required. This means that when an officer requests to see an individual's identification and the citizen voluntarily consents to the examination, there is no Fourth Amendment violation, even when the officer does not have the reasonable suspicion to non-consensually detain the citizen. However, as the Supreme Court explained in the 1973 case of Schneckloth versus Bustamante, quote, the Fourth and 14th Amendments require that a consent not be coerced by explicit or implicit means, by implied threat or covert force. For no matter how subtly the coercion was applied, the resulting consent would be no more than a pretext for the unjustified police intrusion against which the Fourth Amendment is directed. Applying this principle, the U.S. District Court for the Southern District of Florida noted in the 2022 case of United States versus Chavez that, quote, where the threat of arrest is unjustified and amounts to a misrepresentation by a law enforcement officer, at least one court has determined that providing consent in exchange for avoiding arrest can render the consent involuntary. Now, in this situation, although Mr. Neumeyer did tell the officers that they could take his identification, he only did so after he was threatened with arrest for failure to ID. Therefore, if a court concluded that the officers did not have the reasonable suspicion necessary to detain and identify Mr. Neumeyer, it would likely also find that the threat of arrest was unjustified, making any consent received from Mr. Neumeyer involuntary.
No, you're not treating me with respect because you had no right to pull me over. You got no reason to be messing with me. You just heard somebody called and probably didn't call and said that somebody looked over your wall over there, and now y'all feel violated and you want to come punish somebody. So that's why we're here right now going through this. No, yeah, and you would have never said a damn word.
Go ahead and take the cuffs off. We'll cite him for jaywalking and he can move on.
And I want all your name and badge numbers.
That's fine.
You have no legal right to detain me right now. Okay. You think I don't do this all the time? I know exactly what I'm doing.
Okay.
You cannot write me a ticket for jaywalking if I'm over 150 feet away from a crosswalk. You know that. You're only doing this to force my ID. That's the only reason you're doing this, because you're a punk. You want to know my name, so you're going to get it one way or the other, no matter how you have to do it, because you're a tyrant.
I didn't make you run across the road.
You're a tyrant. You know what the laws are. You know I didn't break no laws.
I didn't make you run across the road.
You know I didn't break no laws.
Mr. Neumeyer argues that the officers only stopped him because they wanted to force him to identify himself. As we have discussed before here on ATA, the Supreme Court has repeatedly stated that an officer's subjective motivations are irrelevant to the analysis of whether a seizure violates the Fourth Amendment. Instead, courts must determine whether a seizure is quote-unquote objectively reasonable under the totality of the circumstances. In this situation, this means that if a court concluded that the officers had objective reasonable suspicion to believe that Mr. Neumeyer had committed a pedestrian violation, it would likely also find that it was constitutionally reasonable to detain and identify him, even if the detention was entirely a pretext for the officers' actual stated goal of learning Mr. Neumeyer's name. On the other hand, because reasonable suspicion is required for a seizure and identification to be constitutional, if a court determined that the officers did not have reasonable suspicion to stop Mr. Neumeyer, it would also likely find that his detention and identification violated the Fourth Amendment.
Cite.
Ain't nothing wrong with me. I ain't no psych. I'm perfectly, totally sane.
Citation.
I'll see all of you in court for it too, because I ain't do nothing wrong.
That's fine.
I am legally allowed to cross the street if I'm more than 150 feet from an intersection and I cross at a 90-degree angle. That is the law. You have no right.
Not with
the
cars
only
coming.
reason that you are doing this is so
Okay.
you can force me to give you my name. So exactly what am I being detained for?
I already told you.
You want to tell me again? For
Jaywalking.
Yeah, jaywalking. I was well over 150 feet from the closest intersection, wasn't I?
You have to yield right away to vehicles on the road.
Right away. There were no cars on the road. You were the closest car and you were 300 yards away from me, so don't even try that.
Okay.
You know damn well this ain't gonna fly. You just wanted to force me to tell you my name. I refused to ID myself down the street, and now you want to force me to tell you my name. Guess what? It don't matter. I'm gonna be out here tomorrow. I'm gonna be out here the day after. I'm gonna be out here the day after. I'm gonna be out here every day.
Okay. I don't got a problem with
I'm
that.
gonna show you tyrants what's up. I didn't do a damn thing wrong, and you know it.
That's not true.
You know full well I didn't do nothing wrong. I was well over 150 feet from the intersection. I crossed at a 90-degree angle, and there was no traffic coming. You're a liar.
Says you, but that's not true.
Well, yeah, who's gonna believe me over a blue line thug gang member like you? You don't give a damn about the citizens. You're nothing but a money generator. All you do is generate funds for the city and state. You're a revenue generator. That's all you'll ever be. And you're
You good with him?
Yeah.
All right, here you go, sir. All right, 6450.
I don't need anything from you.
I explained something to you. You got 30 days to either pay
I
it
don't
or
need
contest it in
anything
court.
from you. I'm protesting it. I don't need anything from you. All of you. You.
After the encounter, Mr. Newmeyer challenged the pedestrian citation in court, and he reported that a judge found him guilty. However, the court records are not publicly available online for me to confirm the resolution of his case. It is unknown whether Mr. Newmeyer appealed his conviction, filed a complaint, or pursued legal action against Sergeant Byrd and the Port Orange officers. Overall, Sergeant Byrd and the Port Orange officers get a C at best, because although they maintained calm and professional demeanors throughout the encounter, they either conducted a pretextual stop on Mr. Newmeyer in order to force him to identify himself, or lied about Mr. Newmeyer's conduct in order to justify a Fourth Amendment seizure. While Sergeant Byrd's body camera footage suggests that he did not actually have to slow down to avoid hitting Mr. Newmeyer, the camera did not capture enough of the road to determine definitively whether or not Mr. Newmeyer failed to yield the right of way to passing traffic. However, if Sergeant Byrd actually did falsify testimony in order to detain Mr. Newmeyer, well, then he and the officer certainly deserve an F. It is unclear why the officers became so concerned with identifying Mr. Newmeyer for simply filming in the area near the police department, and it raises the possibility that the officers' reaction had something to do with the fact that Mr. Newmeyer was attempting to file an officer complaint. On the whole, this encounter demonstrates the way that authority to conduct pretextual stops can allow officers to target citizens for reasons other than their stated intentions, such as obtaining an identification. Mr. Newmeyer gets an A for refusing to identify himself when he was not legally obligated to do so, verbally challenging a potentially illegal detention while complying with the officer's orders, and fighting the charge against him the right way, in court. Throughout the encounter, Mr. Newmeyer demonstrated a solid understanding of the Fourth Amendment and Florida's pedestrian laws. He also correctly argued that he was permitted to cross mid-street when Sergeant Byrd accused him of jaywalking, forcing Sergeant Byrd to change his argument and claim that Mr. Newmeyer failed to yield to vehicular traffic. However, it is important to remember that because courts determine reasonable suspicion on an objective basis, a court could still conclude that Sergeant Byrd had reasonable suspicion to detain Mr. Newmeyer based on evidence of a failure to yield, even if that evidence did not influence his actual reasoning for the initial seizure. I cannot say for certain whether or not the stop was legally justified, but I commend Mr. Newmeyer for advocating for his rights and voicing his dissent to the officers. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.